Good afternoon, friends. I, on behalf of Beyond Law CLC and SSR Law Associates, welcome you all to the fourth part of the series of webinars being conducted on motor accident claims. And today the topic is Principles of Assessment under Injury Cases. Those who have been watching us live on the Facebook, on the YouTube, as well as on this webinar, would appreciate the manner in which Mr. Srinivasa Raghavan has been elucidating the law and the principles of motor accident claims, have been well received pan-India on all these aspects, because not only he is an erudite speaker, but he explains all the things coupled with the law in a subtle manner. The fact that he has been teaching in the academies, that is National Judicial Academy and Tamil Nadu State Judicial Academy and regional centers, is a testimony of the fact that even the judicial officers like to get themselves enriched in knowledge from the manner in which he elaborates and explains the things. After the webinar and the seminar where he dissipates knowledge, I don't think that there is any iota of doubt left in the mind of the participant, because the same has been explained in a very simple and a subtle manner. And Mr. Srinivasa Raghavan is also running a webinar series under the banner of Lex Webinar Series, where they have conducted a lot of webinars, and they are about to touch 100 webinars out there. Without taking much time, I would request Mr. Raghavan to take over and start the momentum for the day.
Thank you, Mr. Vikas. Good afternoon. And the topic of the day is about principles of assessment of compensation in personal injury cases. At one point of time, more sympathy is required for persons who are injured very badly, to be frankly, than the persons who are no more alive. The reason that at times the injury might have removed all the physical pleasures and movement and routine activities of the injured person, making him almost worthless living. But anyhow, since they are not dead and very much alive with all the physical deformities and invalidity and what is called the so-called disability or disablement, they need to be compensated for the purpose of putting them in the same position in which they were living before the accident. So whenever the courts are called upon to adjust the quantum of compensation in personal injury cases, the criterion is very simple. I would like to quote an English law. Unfortunately, this English law has been cited in our national journal called ACJ, Accidents Claims Journal. It is a judgment in Baker versus Willoughby, reported in 1970 ACJ, page 259, by arrangement with Halsbury's Laws of England, where Justice Reed, who has delivered the judgment, would in a simple term say as follows: a man is not compensated for the physical injury. He is compensated for the loss which he suffers as a result of that injury. His loss is not in having a stiff leg. It is in his inability to lead a full life. His inability to enjoy those amenities which depend on freedom of movement, and his inability to earn as much as he used to earn or could have earned. This is what is the words of Justice Reed, Lord Reed, in Baker's case in the year 1970. This must be the undergoing principles in the mind of advocates, insurance company advocates or claimants advocates, and more particularly the judges who are going to adjust the quantum. So if this is the introduction, I would like to go to the topic straight. As we all know, the injuries are of two major categories, namely simple injuries or minor injuries and grievous injuries or major injuries. The grievous injuries would result in two kinds of ill health or deformity. Namely, number one, partial permanent disability. Number two, permanent or total disablement or disability. So now, in the year 2011, our Supreme Court has evolved a new formula that is more convincing and scientific, what is called functional disability. The Supreme Court has evolved a new concept called functional disability that would never depend on the percentage of disability. The yardstick or the acid test is whether the total disablement suffered and alleged has resulted in the victim being rendered invalid. In other words, in cases of loss of avocation or loss of job, or the incapacity of the injured victim in cases of loss of avocation to continue the same avocation after the accident is the criterion to decide whether the injury has resulted in functional disability or not. I would like to cite an example of Ekaleva in Mahabharata. Only his thumb was removed voluntarily, not an accident. If Ekaleva had been injured in an accident resulting in loss of his thumb, especially of his right hand, the Workman Compensation Act would give the percentage of disability or loss of earning capacity at the worst by 5% to 10%. But see that Ekaleva can no more be a good rank archer, capable of even beating Arjun. This is what is called a functional disability. Take the legend who passed away, S.P. Balasubramaniam, singer. For example, he was fixed with ECMO. You know, the bore which they used to fit ECMO machine would have a what is called a diameter of 5 centimeter, I'm told. So had S.P. Balasubramaniam suffered an injury in an accident and he was fitted with ECMO, had he survived the accident, assuming but not accepting, he cannot sing. So the bore or the ECMO attachment may not give much percentage of disability as per medical terms, but the functional disability SPB would have suffered is almost near 100%. You take an actress or a model who has got a beautiful, pretty face, and there is a cut injury on her face, the disfiguration is almost 100%. She cannot be the same old beautiful actress or a model as she was before the accident. So while you go for the test of functional disability, it is not the percentage of disability the doctors assess that counts. The test is whether the injured person who suffered an injury or a loss of avocation that he was pursuing before accident could be continued after the accident or not. If the injured person is not able to continue the avocation as a result of the injury he had suffered in the accident, the disability is called a functional disability. That is the case where the Supreme Court, in a case I'll come to a little bit later, speaks of awarding compensation by following the multiplier formula. This is called a functional disability. In case of minor injuries, we all know the amount of compensation is very meager or paltry. It might have a component of medical expenses provided there are bills to support the claim. So it may be 10,000. Now I think the present trend is to give 25,000 with or without medical expenses. In case of major injuries, we have what is called grievous injuries. These kind of major injuries cause two kind of permanent disablement or partial permanent disablement. Here comes the application of what is called the multiplier formula. We are all supposed to refer to the second schedule appended to the Motor Vehicles Act before May 2018, which came into force for the first time in the statute book with effect from 14/11/1994. Before 1994, there was no such formula called the second schedule or multiplier formula in the statute book. It was meant to be a formula for assessment of claim under section 163A only. I may be right or I may not be right, I may be wrong also, but I'm very clear to say that the first column of second schedule, that is the tabulation meant for assessment of compensation is meant for injury only. As you all know that the second schedule has got 8 clauses. First clause is the tabulation form. The tabulation form cannot be used for assessment of compensation in death cases because in the tabulation, the only relevant factor in death cases is the multiplier applicable. So the percentage of disability is the only criterion as per section 163A of the MB Act. And the second schedule is meant to give you a formula for the purpose of computation of loss of earning as per the dependency consent. So the multiplier formula has got 8 clauses, some of which are meant to be applicable for injury cases. Now the question is, before 2018 or since 1994 till 2018, we have a safe formula called second schedule. We were able to what is called an assessment of the disability by having a multiplier formula. For example, a person has suffered amputation of his leg above the knee. The percentage would be 80 to 85% as per the medical literature, and even as per the Schedule 1 of the Workmen Compensation Act. If we are supposed to compute the loss of income in terms of disability, for example, had the doctor has given a percentage of 80%, we would compute it very easily. We will calculate the compensation by having 100%. Out of the 100%, we award 80% being the amount payable to the injured claim. But come 2018 May, the Union government thought fit of removing or deleting or abrogating the Schedule 2 from the statute book altogether, because the Supreme Court of India has held in Sunil Kumar's case that the liability under section 163A is no for liability. A new schedule has been replaced in the statute book in the place of the old second schedule. According to the second schedule in force as of now, after May 2018, the compensation is fixed. It is limited. It is not unlimited. As per clause 1 of the new schedule that has come into force from 28/5/2018, compensation in case of death shall be maximum by 5 lakhs. In case of permanent disability, we are supposed to go to the definition of disability as per the Workmen Compensation Act. The compensation payable in permanent disability will be rupees 5 lakhs into percentage of disability under Schedule 1 of the Workmen Compensation Act, provided the minimum compensation for permanent disability is 50,000, 50. In case of minor injury, without any actual medical expenses, the compensation will be 25,000. So as per the second schedule now in force, please forget the multiplier formula, which is no more the good law as per the statute. Presently, the compensation in case of minor injuries is only 25,000. For major injuries which causes permanent disability, it is minimum 50,000. And for each percentage of disability, it carries 5,000. So maximum is 5 lakhs. In case if the person is incapacitated to the extent of total disablement, 100% into 5,000 is equal to 5 lakhs. And the amount will be enhanced by 5% on every first day of January. So every year, the amount stands enhanced by 5 years. So this second schedule as per the 2008 Amendment Act is in force. For some reason, if Amendment Act of Motor Vehicles Act 2019 is notified, this will also go. The proposed amendment to the third party adjudication as per the Amending Act 2019, if it is notified, there will be no second schedule at all. Section 163A is replaced by section 164. Now we are not worried because as of now, the amendment with relating to third party claims and adjudication has not been notified under the 2019 Act. So as of now, the second schedule as introduced with effect from 28th May of 2018 is in force. Now the question is, what are all the heads of compensation that can be considered in a claim for personal injury cases? I would categorize by and large 10 heads of compensation in case of personal injury cases. Number 1, loss of earning during the period of treatment. If the person is able to prove that his income the court may take into account, or in case of notional income, it is a guesswork of the court. Second head is transportation expenses. Third head is past medical expenses. Fourth head is future or continuous medical expenses. Fifth is loss of amenities. Then comes sixth, attendant charges. Then seventh, pain and suffering. Eighth, expenses for prosthesis or artificial limb. 9, expenses for nutritious food. And 10, compensation for the disability factor. Let me just go to the long and short of what is called the disability. As I already said, when we speak of disability, we can divide the same into 3 subcategories: partial permanent disability, total disability, and functional disability. Here comes the Bible of injury cases. Mr. Vikas, I have already sent a WhatsApp message with the drawbacks of all the cases I'm going to cite today in advance for a change. And the first case that I want to refer is Rajkumar versus Ajay Kumar. This is the Bible for injury cases, as Sharla Verma is the Bible for death cases, or pronounced as the case may be. Rajkumar versus Ajay Kumar is reported in 2011, 1 SEC, 2011, 1 SEC, page 343. This is a very lengthy judgment, a compendium, a classic judgment on personal injury cases, and no advocate who is practicing MBA is supposed to miss this judgment. In the said judgment, Justice Ravindran, as he was then in the Supreme Court, has given 3 separate illustrations. The 3 illustrations would give a total guidance to what could be the amount of compensation that can be granted in personal injury cases. So in case of partial permanent disability, each state has been following a different formula. Strictly speaking, section 163A speaks of only multiplier formula being followed in case of partial permanent disability. For example, 20% means 20% of the amount arrived by following the multiplier formula. But in Tamil Nadu, we have a different formula. In Tamil Nadu, the courts, both in High Court and Tribunal, they give a fixed sum multiplied by the disability percentage. For example, if a person is said to be suffering from 30% partial permanent disability, the courts would give either rupees 3,000 or rupees 4,000 or 5,000 depending upon the date of accident. So in case of 30% and the date of accident is 2018, now the courts are giving 5,000 percentage of disability. So it is 30,000 into 5. So 1,50,000. My endeavor to the advocates on record pan-Indian scenario is one. In the month of May 2018, as I told you, section 163A has been amended in the sense that a new second schedule is replaced. The minimum compensation payable in case of major injuries or permanent disability is rupees 5,000 per percentage. So it is a no-fault liability. So when the union government has chosen to fix an amount of rupees 5,000 for 1% of disability, even in a case of no-fault liability, why don't we follow the same at least in contested 166 claim petitions? So the question of granting rupees 3,000 or 4,000 is no more a good law. If a claim petition is adjudged after May 2018, each percentage of disability in case of partial permanent disability would carry at least rupees 5,000 per percentage of disability. In case of total but not functional disability, we follow the multiplier formula. As I said earlier, if it is 40% or 50% means you have to calculate the compensation at 100% and calculate for the percentage of liability disability has got. For example, in case of 60% partial permanent liability or 60% permanent liability, I'm sorry, what to use the word liability. In case of 60% permanent disability, but it is not a functional disability, the calculation is we should calculate his age with the multiplier and year into 100%. And out of the 100% amount we calculate, we will have to carve out 60% because of the disability concern. Now the question is, in case of functional disability, it must be deemed to be 100%. So whatever amount of compensation payable in death cases is to be paid in injury cases if the disability is found to be 100%. It is not a disability, it is the functional disability. I have a pathetic case where I appeared for the claimant. In his case, he was driving a two-wheeler and a bus owned by the Tamil Nadu State Transport Corporation ran over his right leg first. When the bus was reversed, once again it ran over on his left leg, as a result of which both his legs were amputated as a result of the injury. He has been fixed with prosthesis and he was an engineer at Dubai at the time of accident. He came on a new job and on leave before joining a new lab. I think the tribunal below where I appeared as granted must be the highest compensation in the state of Tamil Nadu for injury cases. A sum of rupees 3 crore and 60 lakhs has been awarded. The matter is now pending before the Supreme, I think, Madurai Bench Madras High Court. This is a fit case to understand the predicament of a person who is injured. I'm not saying because I appear for the claimant. I only share the grief and the practical difficulty of person who are totally disabled to the extent of 100%. In case of amputation of both the legs above the knee, just let us imagine the plight of the injured claimant. Here comes the formula of functional disability of the Supreme Court comes very handy. So the second citation I want to rely upon is that of the Supreme Court in Oriental Insurance Company versus Ram Prasad Verma. Oriental versus Ram Prasad Verma, reported in 2009, 2 SAC, page 712. 2009, 2 SAC, page 712. This is a case where the Supreme Court has held that in case of total loss of earning capacity or total disablement of loss of limb, etc., it should be deemed to be loss of earning capacity at 100%. So he should be treated as if he is dead. That is the formula given by the Supreme Court in Oriental versus Ram Prasad. Then let me just go to the various aspects of assessment of compensation in disability cases. Number one is we come across so often injured claimant dying during the pendency of the original petition. Once again, the formula we are supposed to apply is the formula of causal connection or nexus. In case, if the LRs of the injured claimant who died subsequently are brought on record, they have to prove that there was a causal connection or nexus between the nature of injuries and the cause of death. If it is established that the injury suffered by him in the road accident in question has actually accelerated his death, or if they are able to establish a nexus between the injuries and the death that would have happened much longer, say around even 5 years or 4 years or 3 to 2 years, it can be converted into a fatal accident case in the case of establishment of a nexus. Here, the law of the land is well settled that the postmortem certificate or conduct of the postmortem is not a condition precedent. The only thing is the courts are bothered is whether the claimants who are the LRs of the injured claimant who died during pendency of OP are able to prove to some extent that the deceased was under some continuous treatment till recently before his death. This is the only thing that is to be seen. Next question is functional disability with loss of avocation. As I already told you in Ram Prasad Verma's case, it is a case of near fatal, and in such case, the claim has to be treated to be a fatal accident case, and 100% disability has to be fixed. And friends, please bear in mind that in injury cases, there could be no deduction of any amount towards personal expenses. I'll come to it a little bit later. Number one, we come across the cases where the courts are supposed to grant medical expenses into two parts. Medical expenses that were actually incurred by the injured claimant and medical expenses that are supposed to be incurred after the award. We cannot go on passing an additional award once a matter is disposed of by the courts below. So the courts have taken into account the future medical expenses as the part of the compensation, subject to availability of evidence or requirement of such a future medical expenses. There is a case of Supreme Court in 1995 called R.D. Hattangadi. R.D. Hattangadi's case in 1995, 1 SEC, page 551. This is a case where the Supreme Court has ruled out in case of such a grant of compensation for future medical expenses, there can be no grant of interest on the award. For example, if the courts are inclined to grant any amount for future medical expenses, there can be no interest because interest is given only for the amount incurred by the petitioner or the injured claimant and the amount paid by the insurance company, but not to be paid after a particular date of an event. Once again, the Madras High Court has given the same judgment in Cholamandalam Insurance Company versus Kapil Chand Jain, reported in 2015, volume 1, TNMAC, page 75, where the court has held, a division bench has held that there can be no grant of interest in case of permanent disablement and injury cases. Then prosthesis. Here, I find most of the courts commit a blunder. I'm sorry to say this because this has been bothering me for a long time. All the courts, almost 50 to 60% of the courts grant a fixed amount for a prosthesis. And please have in your mind that a prosthesis is not a permanent fixation. An artificial limb cannot be used for more than 3 to 4 years. The injured claimant has to replace the prosthesis at least every 5 years or at least every 3 years. So whenever there is a prosthesis of artificial limb, please see that the claimants are examining the person who has fixed the artificial limb. Please have in your mind that even after fixing the artificial limb, he has to undergo a training for nearly 6 months to use the process. He cannot walk the very next day from fitting of the prosthesis, and the process will require annual maintenance also. If you could see the prosthesis, you can find there are foam and lining cloth inside that has to be replaced almost on an annual basis. So please bear in mind that the prosthesis requires annual maintenance and replacement at least every 3 to 5 years. So your award should comprise of future medical expenses under the category of replacement chances of the prosthesis to the injured claimant. Then comes the medical bills. Here also the claimant's counsel commit a blunder by not filing the total bill from the hospital concerned. The total bill would make the job of the court very easy because it will comprise almost all the expenses that has been incurred by the injured claimant from the particular hospital. But friends, have in your mind that the hospitals will not include pharmacy bills in the total medical bill. So in case of any treatment in the hospital, which are run by the private, we have to summon the hospital to bring the total medical bill, and also the pharmacy bill have to be produced by the injured claimant separately. In the total bill, the advance amount already paid by the claimants during various periods would have been deducted. And next is an important question I have already discussed during the last session. Whether medical expenses, either whole or in the part, reimbursed on a subsequent or separate contract of insurance called Mediclaim can be awarded by the tribunal under the MB Act. The answer is big no, because it is there in the Supreme Court already in Patricia G. Mahajan's case. Only the amount that has been incurred or paid by the claimant during the lifetime can be reimbursed. In case of medical expenses of Mediclaim policy, already he has been reimbursed. So only the difference between the amount actually spent by the claimant and given by the insurance company can be awarded by the MAC tribunal. This is the case law also in Helen C. Rebello in Maharashtra State Road Transport Corporation, reported in 1999 1 SEC page 90. Helen C. Rebello versus MRCTC, followed by Supreme Court and High Court in various cases. In 2013, the Madras High Court has followed it in a case which I appeared, 2013 ACJ page 1347. It's a case between Cholamandalam Insurance versus A. Saravanan, and subsequently the Division Bench of Madras High Court has followed it. Justice Manikumar led. I'm not sure whether it is reported. Royal Sundaram versus Satya Rao and another, in a case dated 6/10/2015 between Royal Sundaram versus Satya Rao in CMA number 2232 of 2015. Now the question is, what about the future medical expenses? The Supreme Court has held in at least 3 cases that future medical expenses and future eventuality should be considered into account. There are 3 cases: Nahapa versus Gurudayal, Govind Yadav versus New India, and the Lakshman alias Lakshman Maurya versus Oriental. Nahapa's case is 2003, volume 2 SEC, page 274. Govind Yadav in 2011, volume 10 SEC, 683. And the Lakshman versus Oriental is 2012, 1 TN MAC, page 28, Supreme Court. In all these 3 cases, the Supreme Court has held that an award should comprise of future medical expenses and future eventuality, and should not be contained or confined only to the past event and past medical expenses. Now, the question is whether a deduction of 1/3 can be ventured into in case of personal injury cases. The Supreme Court says a big no in the case called New India versus Charlie, reported in 2005 10 SEC page 720, and followed by the Supreme Court in Sharla Verma's case 2009 6 SEC page 121, and again by Supreme Court in 2009 2 SEC page 712. It's called Oriental versus Ram Prasad Verma, which I already cited. New India versus Charlie, Sharla Verma, and Oriental versus Ram Prasad Verma. These cases, the Supreme Court has categorically held that no amount can be deducted in injury cases towards personal expenses. Now, the most important part of the story is the distinction between partial disablement and the total disablement, where there are some kind of confusion prevailing, because in case of opinion by medical board, normally we don't examine the doctors or the medical board in the witness box. So the question that remains to be considered is left to the intelligentsia of the judicial officers and the advocates concerned. I'd like to cite some judgments which may be in a position to throw much limelight as to what could be termed to be a permanent disablement and what could be termed to be only a partial permanent disability and what can be termed to be a total disablement. The case law, that is the Bible, is Rajkumar versus Ajay Kumar, reported in 2011, 1 SEC page 343, followed by the Supreme Court in Ramachandrappa's case, reported in 2011, 3 SEC page 236, and finally Oriental versus Muhammad Nazir, 2009, 6 SEC page 280. Rajkumar, Ramachandrappa, and Muhammad Nazir. These three cases are the cases where the Supreme Court has made a distinction between what is called partial disablement and total disablement. What is called a disablement? If I cite the Supreme Court in Rajkumar's case, disablement means restriction to or lack of ability to perform an activity in the manner considered for a human being. Disablement means restriction to or lack of ability to perform an activity in the manner considered for a human being. And what is meant by a disability? It ordinarily means loss or impairment of earning power. It is not meant to be the loss of limb or not a loss of part of your body. It means loss or impairment of earning power. These are all the definitions that are going to guide us to decide whether it is disability, permanent or partial. Now the question is, most of the states are examining private medical practitioners to decide the extent of disability. It was the state of Kerala which first introduced the system of examining only the medical board. Because, there are stock witnesses and unfortunately there are some stock doctors witnesses also in our state. We cannot say no. So the Madras High Court has come heavily on such practice and has ruled in a case called Tata AG versus Prabhu. Division bench judgment. It is a compendium of the medical board, 2016, volume 1, TNMAC, page 609, where the court has followed the formula and state that there should be no examination of private medical practitioners to assess disability. It should be led to the medical board of the district concerned. Tata AG versus Prabhu, 2016, volume 1, TNMAC, page 609, division bench. Then, what are all the factors to be considered in claim petition regarding injury cases? I don't want to give much details. I want to cite two important judgments of Supreme Court that will decide the factors to be considered in personal injury cases. Number one is R.D. Hattangadi. I already told you. R.D. Hattangadi versus Pest Control of India Limited, reported in 1995, 1 SEC, page 551. Second judgment is Karnataka State Road Transport Corporation versus Mahadeva Shetty, reported in 2003, volume 7 SEC, page 175. R.D. Hattangadi, 1995, 1 SEC, page 551. KSRTC versus Mahadeva Shetty, 2003, 7 SEC, page 175. These two cases would give the factors to be considered in personal injury cases. Once again, I told you what happens if the percentage of disability is assessed at 100%. The Supreme Court in New India versus Charlie reported in 2005, 10 SEC, page 720, has held that in such case, it should be treated to be a fatal accident case. Then, two important catchwords which are used in personal injury cases are the pecuniary damages and non-pecuniary damages. This is a very important criterion in personal injury cases. Pecuniary damages means it is not only the present loss, it is also his incapacity to earn in the future or the improved income. That is called pecuniary loss. Non-pecuniary, it's general compensation. Here I want to cite one English case law because Motor Vehicles Act, till a particular point of time, we were only borrowing the common law, especially from England. It's a case reported in 1869, almost more than 160 years back, 21 London Times, page 326, where Chief Justice Cockburn has taken into account two important things to assess the non-pecuniary damages in personal injury cases. According to Justice Cockburn, in FAIR's case, FAIR FAIR's case, assessment of compensation should take into account two things. Number one, pecuniary loss the plaintiff sustains due to the accident. Number two, the injury he sustains in his person or his physical incapacity to or engaging a life. So these two things are very important to assess personal injury cases. Then, whether loss of earning capacity can be considered to be one of the factors in personal injury cases, the Supreme Court said yes in a case called Mubasir Ahmed. National Insurance Company versus Mubasir Ahmed, reported in 2007, 2 SEC, page 369. Here the Supreme Court has held loss of earning capacity in case if it is available as a matter of evidence is one of the factors to be considered in total disablement in addition to grant of disability or permanent disability. So now the question is how to determine whether the disability is functional disability or not. Because we have already seen that the judgment of Supreme Court of India in Rajkumar's case has given a separate formula, and in such case of functional disability being proved, we are supposed to give compensation on the total disablement basis. The test is not explained according to the Supreme Court in Rajkumar. So the Supreme Court has given the same in one case called Manje Gowda versus United India Insurance Company, reported in 2014, volume 3 SEC, page 584. 2014, 3 SEC, 584, Manje Gowda case, where the Supreme Court has said the test to decide the functional disability or not. The question put by one Kalyani is answered by the Supreme Court in this judgment, Manje Gowda. Please go through judgment, it will give you a better idea. If you are able to have access to Madras High Court judgment, by referring to ACJ, I refer one more judgment of Division Bench of Madras High Court by Justice Sadasivam as he was in Madras High Court then. I remember it was a case called Veluchami's case, reported in, I think I remember very vaguely, 2005 ACJ page 1483. 2005 ACJ Madras High Court page 1483, Veluchami's case, where the Madras High Court sitting in division bench has given a detailed formula about what is called a total disablement, whether disability can be assessed to be on the basis of multiplier formula. Now, there are disputes once again whether loss of earning capacity can be considered as a separate head of compensation after granting compensation for permanent disability. The issue is somewhat debatable, and the Supreme Court has held in two cases, which is permissible, but in case of total disablement only. A tribunal can grant compensation under both heads, namely loss of earning capacity as well as permanent disability, only if there is evidence to show that there is injury has resulted in total disablement or functional disability. In case if there is an amputation of leg or hand because of which the injured claimant has been totally rendered as invalid, the court has to consider grant of both heads of compensation, namely disability as well as loss of earning capacity. The judgments are Manikam versus Metropolitan Transport Corporation, 2013, Volume 12, SCC, page 603. Manikam versus Metropolitan Transport Corporation, 2013, 12 SCC, page 603. Kavita versus Deepak, 2012, Volume 2, TNMAC, page 362, Supreme Court. Kavita versus Deepak, 2012, 2 TNMAC, 362, Supreme Court. And Cholan Roadways Corporation versus Ahmad Tambi. This is by Division Bench of Madras High Court in 2006, ACJ, Madras High Court, 2703. Whenever I have cited Madras High Court, Supreme Court, I have given the equivalent Supreme Court citation to Mr. Vikas. He'll circulate a little bit later. These three cases are in the nature of holding. In case of total disablement and functional disability, the courts have to consider grant of dual compensation under the head of permanent disability as well as loss of earning capacity. Then, examination of medical practitioners in the court. How to examine the medical practitioners? The Supreme Court has given detailed guidelines in Rajkumar versus Ajay Kumar, 2011, 1 SCC, page 343. Now your question arises. In case we are supposed to examine a private medical practitioner, in addition to examination of the medical board, most of the judges would like to say, or most of the advocates would like to argue that the same doctor who treated the petitioner was not examined. So the person who has examined the patient much after the date of accident, after 5 or 6 years of the accident, may not be in a position to assess the disability well. So whenever there was an examination of a doctor with regard to disability, who assessed him or the assessed disability much after the accident, and who was not the same doctor who treated the petitioner, the Supreme Court said need not be the same person. The practical difficulty is that there may be a case of an accident in Mumbai for a person who had come for the purpose of business or some purposes. He need not be a resident of Mumbai. He would have come to Mumbai and got injured. He can file a claim petition in the place appropriate as per the Motor Vehicles Act, need not be confined to Mumbai. So for such a person, for example, a person from Chennai has gone to Mumbai, met with an accident, and he has been treated there and has come to Chennai and filed the claim petition. For some reason, the claim petition is maintainable. He is not supposed to summon the doctor from Mumbai. The Supreme Court said it is not necessary that the same doctor who treated the petitioner be examined for the purpose of proving disability. In the same judgment of Rajkumar versus Ajay Kumar, the Supreme Court has held so, and also held that in the event of any discrepancy or doubt about the reliability of the doctor's evidence, the court may also resort to the medical board for clarification. This is what the Supreme Court held in Rajkumar's case. Now the question is rate of interest. This I want to deal in fatal accident cases. Motor Vehicles Act is the only act which restricts the grant of interest from the date of claim petition. There is a glaring discrepancy between the Workmen Compensation Act and the Motor Vehicles Act. The Workmen Compensation Act speaks of grant of interest from the date on which it fell due. It has not given any specific formula what is the date on which the amount of interest is payable. But Motor Vehicles Act is very clear. It restricts the grant of interest only from the date of filing claim petition. It does not give any leverage for granting interest after a particular date before the date of accident. So this is the issue that has been dealt with by the court, and section 171 of the Motor Vehicles Act speaks the interest shall be paid from such date not earlier than the date of making the claim petition. In such case, the rate of interest is not fixed by the act at all. It is silent. So the Supreme Court has been holding what is the current rate of interest payable for fixed deposit by the Supreme Court by the Reserve Bank of India should be the rate of interest. So when what is the date of adjudication? On a particular date of adjudication, what is the rate of interest payable by the Reserve Bank of India for nationalized bank in fixed deposit rate is the rate of interest. So it may be 12%. Now I understand that it is 7.5%. This is how the rate of interest was born. It is reported in a case called Rajapriya, In 2005, 1 TNMAC, page 341, Supreme Court. I given citation, you can see it later. Then, what is the formula to be followed in case of disability which is neither minor nor functional, like a case of partial permanent disability? The Supreme Court has held in such cases to follow the multiplier formula for the cases that fell before 2018. There are 4 case laws: Arvind Kumar Mishra, Sri Kumaresh, and Mohan Soni by Supreme Court. Arvind Kumar Mishra is reported in 2010, volume 2, TNMAC, page 383, Supreme Court. Sri Kumaresh, 2011, volume 2, TNMAC, page 10, Supreme Court. And Mohan Soni versus Avatar Thoman, 2012, 1 TNMAC, page 144, Supreme Court. I have given equivalent citation SEC to Mr. Vikas. You can check it out later. And there is one judgment of Madras High Court in 2012, volume 1, TNMAC, page 611, Division Bench, which speaks of non-application of multiplier formula in case of even amputation if the person injured is able to continue the same avocation. There are 2 cases, in which one case where the injured was a bank official. Another case, an injured was a manager in a lodging house. In both the cases, they suffered injury and one of the legs of the injured claimants have been amputated in both the cases. In both cases, the Division Bench of Madras High Court refused to follow the multiplier formula, stating that these 2 persons whose leg have been amputated, they have not lost the avocation. They continued the same job after the date of accident. So the question of application of multiplier or second schedule would not apply, for the simple reason, to borrow the words of Supreme Court, there is no functional disability. So the only test is this: if the injured claimant is able to prove that he has suffered a loss of avocation or loss of earning capacity, as a result of which he is not able to continue the same job after the accident, it is a case for the multiplier formula. If he is able to continue the avocation, means there can be no multiplier formula. There is one more reason for this case law, because the Kannairam's case, 2012, 1 TNMAC, page 611, Division Bench, the Madras High Court state, in case of employees of the government department, we have got an act called Removal of Personal Disability Act, according to which no person can be removed from service if he has suffered a disability. For example, a driver of a transport corporation bus is injured and his leg is amputated. He cannot be dismissed from service. He should be employed in the same department, in the official office department or some other category, without any loss of reduction of payment and without loss of rank. So whenever there is no loss of job or loss of income or loss of avocation, no question of application of multiplier theory can be invoked into. And the most important aspect of the injury cases is loss of amenities, where I find that loss of amenities is not considered to be a major factor by some of the courts. Like in case of fatal accident, a small amount is given for loss of life estate. I think it is 15,000 as per Pranay Sethi's case. Here, loss of amenities has got a checkered history in the common law or the English law. The Supreme Court has given a detailed account of this head in Rajkumar's case, but I find one judgment of Madras High Court is more fascinating in loss of amenities. It is Cholan Roadways versus Ahmad Tambi, 2006 ACJ, page 2703, Madras High Court. Here, the loss of amenities is put on par with loss of expectation of life. The Madras High Court says loss of amenities and the loss of expectation of life means deprivation of the ordinary experiences and enjoyment of life. The injured person is deprived of ordinary experiences and enjoyment of life, and it includes loss of ability to walk or see, loss of limb or its use, loss of congenial employment, loss of pride, that's very important, loss of pride and self-esteem, and loss of pleasure in one's own work. What a beautiful word. It means deprivation of the ordinary experiences and enjoyment of life, and includes loss of ability to walk or see, loss of limb or its use, loss of congenial employment, loss of pride, and loss of pressure in one's own work. So this is very important criteria or factor in matter of injury cases. And I have come across the judgment of Supreme Court recently, that is in 2020, where 3 judges of Supreme Court, including our Chief Justice, have given a very important judgment on the right of the claimants to seek more compensation in the appellate stage by filing a cross objection. You may be worried, what is the beauty in this? The question is whether an injured claimant can claim compensation by way of a cross objection in an appeal filed by the insurance company only on the liability. There are cases where the insurance company wouldn't have filed the appeal except on the grounds of the liability or to some extent negligence. When the grounds of appeal of the insurance company is confined only to liability and negligence, and there is not even a single ground of quantum of compensation being raised, the law was little bit dilly-dallying between a yes and a big no, and now the Supreme Court has given a judgment by a 3-member judge, so it is binding on regular bench. It is the case law between Urmila Rani versus National Insurance Company, reported in 2020 AAR Supreme Court, page 709. AAR 2020 Supreme Court, page 709, Urmila Rani versus National Insurance Company. Equivalent citation 2020 CDJ, Complete Digital Judgment, Supreme Court, page 108. Whether the Supreme Court has held that cross objection by the claimant on quantum is maintainable perfectly, though the insurance company has not raised the issue of quantum in the appeal, because it is the inherent power of the court under Order 41 to 33 under CPC. So for an appeal, such a power cannot be denied. So even in the case of an appeal being filed by the insurance company or the transport corporation or whoever is the appellant, without touching the correctness of the quantum of compensation, the claimant has got every right to file a cross objection to seek enhancement of compensation in the cross objection without the quantum being questioned by the insurance company or transport corporation. So these are all the broad categories under which I can sum up the judgment of various high courts. Before parting the lecture, I just want to touch upon one judgment, one aspect. Since the matter is listed with the Supreme Court, I don't want to dwell into its much details. I will be feeling guilty if I don't touch this important topic. This is tax deductible at source or income tax on the quantum of compensation in an award under the Motor Vehicles Act. The matter is now pending before the Supreme Court. So it won't be proper on my part to dwell into much on this aspect. And recently, a single bench of Madras High Court has referred the dispute to a larger bench because Madras High Court has differed with each other and there is a clash of judgment. You all know that income tax has been amended in the year 1991, wherein compensation payable under the Motor Vehicles Act is taxable. It was also the case under the Land Acquisition Act. But when the Government of India introduced a new Land Acquisition Act by what is called a Fair Compensation Act, it has specifically contained a provision stating that no amount of compensation for land acquisition can be assessed to income tax. There is a bar under the Fair Compensation Act, but such a bar does not find a place in the Motor Vehicles Act. So we are now governed by the Income Tax Act only. Income Tax Act has got a provision of law, section 194A19, according to which if the interest component of an award given by the Motor Accident Claims Tribunal under the Motor Vehicles Act exceeds rupees 50,000, such an amount in excess of rupees 50,000 is taxable under the Income Tax Act. And this amount has to be deducted at source by the person who is paying the amount. It may be a transport corporation or the owner of the vehicle or the insurance company. So the issue is twofold. In cases where compensation is awarded in injury cases or death cases, when the interest payable exceeds 50,000, that part of the amount is liable to be income tax and it should be a matter of tax deductible at source. In case of fatal accident cases, the award has to be apportioned between all the claimants and the apportioned amount should be construed individually to decide whether income tax is attracted or not. In case of personal injury cases, there is no such escape. In case if the interest goes above 50,000, the amount is taxable. So far, the validity of this provision has not been challenged. And now, an award from the Agartala High Court has been challenged before the Supreme Court. The Supreme Court has admitted the matter, SLP has been admitted, civil appeal has been numbered, and now there has been a stay against the deduction, against omission to deduct the amount. So as of now, the provision of the Income Tax Act continues. So there is no other alternative for the tribunals than to permit the insurance company and the respondent to deduct income tax at source. For that amount, there has been a stay by the various high courts also. So only after disposal of the petition by the Supreme Court, we will be in a position to see whether the taxable amount of the interest is removed or retained in the Act, or it may be the legislative wisdom or the parliamentary wisdom of the members of the parliament to delete the provision of law for the Income Tax Department. As of now, the insurance company or the transport corporation or the person who makes the payment is under a duty by law to deduct income tax at source whenever the interest component of the award exceeds rupees 50,000, and if he fails to do so, he is liable to be punished by a penal clause. So there can be no escape. For the rest of the history in income tax versus motor vehicle act, please wait till the Supreme Court decides the matter once for all. So with this, I may conclude my topic, and I leave it to Mr. Vikas to take the podium.
As usual, Mr. Raghavan, the topic was spot on, and with what I said on the previous date of as a lawyer, you keep on saying previous date of hearing on the previous webinars part, that there was a flurry of judgments matching as at par with the IPL match where the sixes are going on in the same manner. The judgments are coming on in a flurry. We have shared the judgments at the outset as we had discussed in the WhatsApp group. If you remember, you had given a lot of citations for reference to the Rajkumar's case. There, just like you gave the illustration of Eklavya, there also they give two illustrations. Let's assume that there is a driver and his leg is amputated, then his functional disability would be different. If he's a typist and if he loses his hand, then it's different. And let's assume he's a typist vice versa, and he loses his leg, and his functional disability to that effect will not be to that level. Whereas, and what you said of that judgment of referring at that he could be given the alternate job, that the Act of 1995 and as amended of the Disability Act. Even the judgment of Kunal referring after the judgment, the Honorable Supreme Court, it says in terms of Section 47 of the Disability Act, you have to give an alternative job which is of the equivalent status, and you cannot even lower the pay.
So there can be no reduction of rank and reduction of payment.
This is by TV Suresh. So rupees 5,000 per disability is stated in the Act as maximum. Is it mandatory if I am correct? What is
rupees? That is the WC Act. That is an Workman Compensation Act. There is no such bar or ceiling in the MV Act. MV Act does not speak of any ceiling of compensation in case of injuries. As per the second schedule introduced from May 2018, the minimum compensation for minor injury is 25,000. Minimum compensation for permanent disability is 50,000. For each percentage, the court has to give 5,000. Maximum is 5 lakhs. That's all. So 5,000 is the minimum compensation for 1% of disability the court has to give. Each person of disability. So 100% means 5 lakhs.
Arun Kumar is, what is the liability of the insurer in invalid or a fake driving license? Is pay and recovery applicable in the same
invalid
case?
Driving license is as good as, even in case of fake driving license, absence of driving license, we are giving pay and recovery. Invalid is only a discrepancy. Invalidity is maybe as against a period or as against type of vehicle. For example, a person who is having a license to drive a two-wheeler might have driven a car. He is not totally debarred. So invalid driving license is much inferior to a total absence of driving license or a fake DL. Even for fake DL and no DL, we are giving pay and recovery. So invalid DL will result in pay and recovery provided the unladen weight of the vehicle is less than 7,500, means there is no question of any endorsement available. If the unladen weight of the vehicle is more than 7,500 kilogram, the driver has to got an endorsement of additional license. That's the only difference. It's a case called Mukund Devangan by Supreme Court in the year 2017.
This is by Shankar. Probably is working in future generally because he's logged in by the email. If in the case of a functional disability is not affected, but there is a physical disability, then is it can take physical disablement?
The judgment of Supreme Court of India in Rajkumar case is very clear that unless there is a functional disability, there is no question of taking loss of earning capacity at all. The functional disability is the only criterion to decide whether the injury has resulted in a loss of earning capacity. Unless there is a finding by the court below that the functional disability has resulted in loss of earning capacity, there can be no grant of compensation on par with death cases or at 100% or on case of total disability. That's why he said the question of Yaklaiva or a beautiful actress who's having a disfiguration or an acid attack victim who suffered an injury on the face or like a singer who lost his throat. It may not have much disability under the act, but the functional disability would result in loss of earning capacity. That's why he brought the legendary singer SPB as an example.
This is by Kalyani. What is the formula for calculating loss of earning capacity in functional disability cases?
That's what I say. I said, please once again go through judgment of Supreme Court of India in two cases, Ram Prasad Verma and Rajkumar. These two will give you a better example. They have given almost each and every formula to decide these case laws. Please do some
Rajkumar is quite elaborative.
Quite elaborate, but it's comprehensive. Sir. It's almost, if you have read Rajkumar well, there will be not even an iota of doubt.
It says where the medical board has to be done and how medical board has to be examined.
One of the best judgment, I would say, it's the Bible on injury cases.
Yes, that's good. This is why Azad Singh, nowadays we generally see that roads are not up to the desired quality and have potholes and in damaged conditions. Generally, road accidents also happen due to worse conditions of road. My query is whether there is any provision to prosecute and claim damages in the concerned authorities for damages and accidents happen to public at large.
It's because you may remember the conversation myself and you had with Vimala in the very first session.
Yes.
On the similar nature.
Law of torts.
That's what. So, whenever an accident is caused not on account of any negligence on the part of the vehicle, but only on account of the dereliction of duty on the part of the public department, it is a state negligence. So, unless there is a negligence on the part of the drivers involved, in the absence of negligence of drivers, are the accident taken place due to improper application of speed breakers or inappropriate places where the barriers are placed, or maintenance of the road, or there is no display board, signboard regarding pits and potholes, you can file a writ petition under Article 2, there is no bar against the state. And the amount of compensation is out of the road tax we are paying for each and every vehicle. It runs into huge crores of rupees. And we are paying the toll plaza. Yes. So a writ petition can be filed.
There's a judgment. In fact, there is a judgment by Justice Rana upheld by the Supreme Court out from Punjab, Haryana.
Yeah,
it was due to the animal also. Do not control the animal maintenance.
It is the duty of the state government to see that the animals are not put let on the roads.
Same way, electrocution. There are judgments on the electrocution.
Yeah, we have got law of torts well settled. The only thing is, advocate should be aware of the law. My senior used to say, half of the knowledge in law lies in finding out where the law is. You find out where the law is, the rest is almost made easy.
My senior used to say, you need not know the law, but you should know how to find the law.
So I say, where to find the law is the half knowledge in law.
This is by TPR. Any case law about release of amounts of minor?
No, it depends. That's why I say it depends the state rules. Every state has got its own state rules, MACT rules. In Tamil Nadu, in case of minors, the courts only release the medical expenses incurred by the father on proof of medical expenses. Otherwise, minors amount are not released in Tamil Nadu. Rest of the states, I think it is left to the local state rules. I'm not sure of other states.
This is by TV Suresh. He says pay and recover provision itself is omitted under the new act. Then what is the way forward?
Pay and recovery is strengthened by, made very specific in the new act. So wait till the new act is notified.
Yes. I will check it out on the Facebook because the question out here we have done.
Yes, sir.
Their only message of praise that it is a well-conducted session by Mr. Raghavan.
Thank you, sir. Thank you. In fact, I request the participants not to worry about the new act. 2019 Act is not yet notified regarding third-party adjudication. I've been telling wherever I go, please ignore the new act unless you are sure that it is brought into force. As of now, IRDA and the Government of India are holding series of consultation regarding base premium concept. Unless and until the base premium concept is settled by the Government of India and IRDA, the section regarding a part or chapter regarding third-party adjudication will not be notified. Till then, we are governed by the Motor Vehicles Act 1988 as on it in force, at least regarding third-party claims. No question of going to the new Amendment Act.
Thank you, Mr. Raghavan. The session, we have all been enlightened, and especially being enlightened during these testing times is more enriching for one's mind. And when the mind is good, then what we are talking about nowadays, before the lockdown, it was never considered of mental training, mental health. This is another facet which has emerged. And the webinars is another flip which has improved that knowledge has no barriers. So learning from people like you has always been heartening, not only for me, but for all the participants who are watching us on the Facebook, on this platform, and subsequently on our channel of Beyond Law CLC. It's always happening. Tomorrow, in that pursuit of the webinars, we are also doing a series, just like we did on motor accidents, on the online mediation. On the previous session, Mr. Jawad, who is a well-known and a nationally acclaimed mediator, he had given on the communication skills on online. Tomorrow, he says, becoming a digital dispute resolution specialist. What is the way forward and how one can do? I would request all the participants to join tomorrow at 4:30. Tomorrow there will be two speakers. One is from abroad and he's also a very acclaimed trainer, Rahim Shamji. He's the CEO of ADR ODR International, along with Mr. AJ Jawad. Mr. Jawad has also been taking classes in the national law universities, in different universities and different colleges, as well as in different academies. So much so, he had also come to Punjab Haryana High Court, and we were all, and that's how I got connected with him. And from physical to virtual is a journey which we have come across with Mr. Jawad. So everyone stay safe, stay blessed. Namaskar, and tomorrow we will meet at 4:30.